We go now to the limitations in taxation power. Limitations in taxation power. So whenever we talk about limitations in taxation power, we talk about your restrictions in the power of taxation. So in passing tax laws, this restricts the coverage of the tax law. This restricts the coverage of the tax law. So your limitations in taxation power is from your inherent limitations and your constitutional limitations. So when we say inherent limitations, by the nature of the power, this is already within it. So these are limitations by the use or nature of the taxation power. So we start first with your first inherent limitation, public purpose. Public purpose. So the inherent limitation of public purpose tells you that taxation power should be levied always for public purpose. It means that everything that is levied through taxation must be used for public purpose. If ever it is for private interest, that cannot be. That cannot be. It cannot advance any private interest. It can only advance public purpose or public interest. Next, exemption of government from taxes. The next inherent limitation is exemption of government from taxes. So when we say exemption of government from taxes, it means that the government, together with its political subdivision, is exempted from taxes. The government, together with its political subdivision, is exempted from taxes. So you cannot just tax yourself. You cannot just tax yourself. So government cannot impose tax on itself. So we cannot tax government together with its political subdivisions. So when we say political subdivisions, those under the executive. So those different departments, bureaus under the government. Next, non-delegability of the power to tax. We keep on emphasizing this one, that the power of the tax cannot be delegated and is solely lodged to the power of the legislative. Next inherent limitation, number 4, territoriality. Under your territoriality principle, it means that you can only tax those persons, businesses, rights, or privileges that is within your means and bounds. Meaning, it must be within the jurisdiction of the Philippines. So you can only tax within the jurisdiction of the Philippines. This shows that our tax law applies only, tax law applies to anyone within the Philippines. Okay, so you cannot say, oh, US, you tax that person based on our laws. That is already overbreadth. You can only tax within your jurisdiction. So your jurisdiction is the Philippines. Therefore, the metes and bounds of the Philippines, there we can only apply the laws regarding taxation. So it cannot go over or beyond Philippines. Next, international committee. This international committee shows you the respect among foreign nations or respect to states. Take note that each state has the inherent power to tax. And since each state has the inherent power to tax, we must respect each state. We must respect each state as to their inherent power to tax. And also, international committee gives you the right of each state not to be taxed by another sovereign state. So if ever you have here Philippines, Philippines is a sovereign state. And we have here US, another sovereign state. Under the international committee principle, each sovereign states cannot tax each other. So for example, Philippine government cannot tax US government. At the same time, US government cannot tax Philippine government under the principle of international committee. Okay, so international committee, one principle there is, again, each sovereign state has its own power to tax. Next, you respect each sovereign state in such a way that you do not tax the government of that sovereign state. So Philippine government cannot tax any state government. So the government of China, the government of Korea, the government of India, whatsoever government. Okay, that is under our international committee. So we only have five inherent limitations. Normally, in the board exam, these items only are questioned once it is on the theories, which item is that an inherent limitation, ganun lang. But it is not really applicable as to the different applications or problem solving. But again, take note, these items are used to draft our tax laws. Meaning, alam na nung ating Senate na, oy, hindi naman pala pwede to kasi hindi for public purpose. These are already restrictions as to the taxing power of the legislative. We go now to the constitutional limitations. Constitutional limitations. So why is it constitutional limitations? These are restrictions on the power of taxation that can be found under our constitution. Okay, these are limitations on the power of the taxation which can be found under our constitution. So first one, observance of due process of law and equal protection of the laws. That is under Section 1, Article 3. So this Section 1, Article 3 talks about your due process clause and your equal protection clause. So due process clause, due process laws, and equal protection laws. So it is composed of two clauses, due process laws and equal protection clause. When we say equal protection clause, you go back to your equal or theoretical justice or ability to pay principle. Same lang siya. How about under your due process clause? Under your due process clause, it states that no person shall be deprived of life, liberty, or property without due process of law. So for example, you apply tax law, it must undergo due process. And when we talk about due process, it is composed of two. First, we have your substantive due process, or the due process under the law, and we also have your procedural due process. This is due process or process as to the procedure. So for example, you are to assess someone. So you cannot just get the property of that person without the necessary process. Kasi nga sabi natin, we must observe the due process of law. So you must observe both substantive and due process. When we say substantive, it must be within the law. So you assess that person within the law. If you did not assess the person within that law, then mali yung assessment mo. Next, you follow the procedure provided under the law. So let's say you want to assess a person, you just took the property. Is that right? No, because under the law, our procedure to take the property in case we will take the property, first we must have a pre-assessment notice until it will become a final assessment notice. But remember, you must first collect money. In case you cannot collect money, you can go with levy or restraint of the property. You cannot just get a property without due process, okay? So substantive and procedural due process. So in applying tax laws, you must follow due process and of course the ability to pay principle under Section 1, Article 3. Next, rule of uniformity and equity in taxation, Section 28, Paragraph 1, Article 6. So in this particular limitation in taxation power, this talks about the power of the legislative to pass tax laws. And when you pass tax laws, you must have a proper classification. You must have a proper classification. Hindi pwede na lahat ng franchise, ibang franchise, 10% ang tax. Tapos Jollibee, 15% yung tax. Jollibee, franchise din. Ganon. So whenever we say uniformity and equity, if there is a classification that is placed under the law, it should apply to all classification uniformly, not only to certain classes. So for example, our classification is franchise. All franchises should be taxed 10% except Jollibee. That cannot be because again, apply it uniformly. Rule of uniformity and equity under Section 28, Paragraph 1, Article 6. Next, no imprisonment for non-payment of poll tax. Take note, what is only given under our Constitution is the non-imprisonment in case of non-payment. Non-payment of what? Poll tax. Sir, what is a poll tax? Poll tax is known as your capitation or your cedula. Normally, you find your cedula in your city hall under your treasurer's office. You go to the city hall, you pay cedula. And normally that is under 5 pesos, under the 5 pesos to 5,000 pesos. It depends on your annual income. So you must pay annually for your poll tax. You must pay annually for your poll tax. Sir, what if I will not pay? Will I be imprisoned for tax evasion of poll tax? No, because under Section 20, Article 3, you cannot be imprisoned for non-payment of poll tax. So even if you did not pay your poll tax or cedula, you cannot be imprisoned. Sir, let's say I am not paying for 10 years. Can I not be imprisoned? Sabi nga, di ba? No imprisonment for non-payment. Even if for your whole life you did not pay poll tax, you cannot be imprisoned. But ibang kwento na yan, pagka fake poll tax, you can be imprisoned. What is only guaranteed under our Constitution is the non-payment of poll tax. But other violations as to poll tax, it is not guaranteed by our Constitution. Next, number 4, non-impairment of obligations and contracts. Okay, we have already discussed this one. Taxation power is inferior to the non-impairment laws. Therefore, tax laws cannot impair existing obligations and contracts. That is under Section 10, Article 3. Tax laws cannot impair existing obligations and contracts. Other constitutional limitations, number 5. Prohibition against infringement of religious freedom. Prohibition against infringement of religious freedom. In this case, if there is a tax law, it should not regulate religious freedom, meaning it should not suppress religious freedom. For example, you cannot pass a tax law which taxes 100% a particular sector of religion. So for example, religion A, religion B, religion C. Hindi pwedeng sabi mo, ayaw ko tong religion C. I-tax ko nga to ng 100%. Bawal yon. Because you will infringe their religious freedom. Sir, for example, nagbebenta si religion C ng mga Bible. Nagbebenta siya ng Bible or pamphlets. Tapos itatax siya ni government. Pwede ba yon? No. Kasi nga, religious freedom nila na gumamit ng Bible, na gumamit ng pamphlet na yon. So, bawal mong itax yon. So, anything that will infringe their practice of religion is a prohibition. That is a prohibition. Okay? So, that is for number 5, prohibition against infringement of religious freedom. Next, number 6, prohibition against appropriations for religious purposes under Section 29, Paragraph 2, Article 6. If the first prohibition is any prohibition on taxation of religious freedom, number 6 is a prohibition for our taxes to go to any religious sector. So for example, you cannot provide, let's say, religion A, religion B, religion C. The government cannot appropriate our taxes to religion C. Parang gusto ko ng religion C, ibigay ko nga lahat ng ate, magbigay nga tayo dito ng 500,000. Bawal yon. Because our taxes cannot be appropriated for religious purposes. Because they have their religious freedom. Okay? That is for number 5 and number 6. Number 7, exemption of all revenues and assets of non-stock, non-profit educational institution. So what is the exemption? Exemption over taxes. What kind of taxes? Taxes on revenue and taxes on asset. Taxes on revenue and taxes on asset. So taxes on revenue, they are exempted on income taxes. Taxes on asset, they are exempted on real property tax, donors tax, and custom taxes. Custom taxes, okay? So, exemption. This is an exemption provided in our Constitution. So, if ever we have a non-stock, non-profit educational institution, take note na, non-stock, non-profit educational institution lang. And those revenues and assets are used actually, directly, and exclusively for educational purpose. So that is a non-stock, non-profit, educational institution, used for educational purposes. Sir, what if I have a non-stock non-profit educational institution? 80% doon, actually, directly, exclusively. 20% nun, others. Paano yung taxation? Matatax ba ng buo? No. Take note, you are exempted for actually, directly, and exclusively. So the 80% is exempted. The 20% is tax. Okay? So for example, actually directly for educational and the 20% for proprietary functions such as nagbebenta ka ng books, nagbebenta ka dun sa canteen nyo, gano'n. Di ba uso sa mga educational institution yung may canteen. So those are proprietary functions. So they are tax. They are tax. Okay? So what is only exempted? Only those actually, directly, and exclusively used. Only those actually, directly, and exclusively used. Exemption as to what? Taxes, revenue, and asset. What taxes? Income taxes, real property taxes, donors taxes, and custom taxes under Section 4, Paragraphs 3 and 4 of Article 14 of the 1987 Constitution. We proceed further. Number 8, concurrence by a majority of all members of Congress in the passage of a law granting tax exemption. So take note, guys, if ever there is a tax law, and the tax law provide for tax exemptions, there must be a concurrence of majority of all members. So when we say Congress, it is composed of two. We have your Senate and your House of Representatives. So when we say concurrence of majority, i-add mo yung members ng Senate, i-add mo yung members ng House of Representatives. Kailangan majority nilang lahat bago ma-approve yung tax exemption. Okay? Take note. Before a tax law provide for a tax exemption, there must be a concurrence of majority of all members of Congress, meaning both Senate and House of Representatives. That is under Section 28, Article 4, Paragraph 4, Article 6. Okay? Majority voting requirement for tax exemptions. Number 9, Congress may not deprive the Supreme Court. So this is the power of Supreme Court to review. Power of judicial review. So what is the power of judicial review under Article 8? Under Article 8. So the power of judicial review stems under tax cases and under tax law. So what are those tax cases? So for example, you have a tax case under the RTC, Regional Trial Court, Municipal Trial Court. Those can be reviewed by the Supreme Court. So, ang mangyayari kasi, MTC muna. Kung hindi sa MTC, sa RTC. So, MTC or RTC, pag natalo ka doon, pwede mo yung i-appeal sa Court of Tax Appeal. Pag natalo ka sa Court of Tax Appeal, pwede mong i-appeal sa Court of Appeals. Pag natalo ka pa rin sa Court of Appeals, ang last mo ng judicial review ay Supreme Court. In case may kaso ka regarding taxes. How about tax laws? When we say tax laws and it is under power of judicial review, we are reviewing the constitutionality of the tax law, whether the tax law is constitutional or unconstitutional. Sir, what do we mean whenever the tax law is constitutional or unconstitutional? We say that so power of judicial review under the tax law. When we say power of judicial review under the tax law, the Supreme Court will review whether the tax law is constitutional or unconstitutional. So when we say whether the tax law is constitutional or unconstitutional, whether it is within the Constitution or provisions of the Constitution. If it's not within the provisions of the Constitution, it is unconstitutional. If it is within the provisions of the Constitution, it is constitutional. So power of judicial review, you can review both tax cases and tax laws. That is under constitutional limitations number 9. So even if there is a tax law, guys, even if there is a tax law, it does not mean that it's already okay because the judiciary through the Supreme Court can review that tax law. The judiciary through the Supreme Court can review the tax law. Next limitation in taxation power. Next limitation in taxation power, number 10, the rule requiring that appropriations, revenue, tariff bills shall originate exclusively from the House of Representatives. So what's this one? Remember, whenever you have a law that may come from your Senate or your House of Representatives. And at some point, they can have bicameral legislation. Okay. What is this particular constitutional limitation? Remember here, tariff bills. Tariff bills is a form of tax law. So tariff bills will always come from your House of Representatives. Bawal daw siyang manggaling sa Senate. So pagka merong bill regarding tariff, kanino lang manggagaling dapat? House of Representatives. Bawal sa Senate. Sir, paano kung nagpasa si Senate? Pwede ba yon? No, it is unconstitutional. It must come from your House of Representatives. Next constitutional limitation, number 11, the power of the president to veto. So this is known as the veto power of the president. Veto power of the president. So if there is a law, our laws can either be passed, meaning it is signed by the president. Okay? Our law can either lapse, not signed by the president, within 30 days. So let's say you pass a law, the Congress pass a law. Within 30 days, the president must sign it. If the president will not act on it within 30 days, then it will lapse into law. It will lapse into law. So it is a law by inaction of the president. And lastly, it can be vetoed. So what do we mean by the law being vetoed? It is rejected by the president. It is rejected by the president. So if there is a law, especially a tax law, it can be vetoed by the president. It can be rejected by the president. And normally, if the rejection is based on a tariff, appropriation, or revenue bill, what do we call this veto? We call it your packet veto. Packet veto. For normal laws, it can be an item veto, a particular item of the law. So for example, RA 1111. RA 11111. Ang haba naman. RA 1111. That is our law. Now, under that law, ayaw ni President yung Section 7. So, I veto Section 7 due to blah, 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 blah. So, kung particularly Section 7 lang yan, we call it item veto. But if ever the item veto is a tariff bill, so Section 7, the tariff that is placed on a custom of blah, 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 ganun nakalagay, halimbawa. Yan yung vinito ni President, ang tawag natin ay pocket veto. So bakit meron tong veto power? Dito malalaman ninyo na kahit merong law na pinas ang Senate or Congress or ang HOR, pwedeng i-veto or i-reject ni President. That is the veto power of the President. Another constitutional limitation on the power of taxation in case we have a tax law that will be passed. That is number 11. We go now to number 12 and the last constitutional limitation, the freedom of speech and of the press. This is the same with the freedom of religion. You cannot make use of tax law to suppress speech and the press. You cannot make use of tax law to suppress speech and of the press. So for example, ABS-CBN, you cannot tax 50% of the earnings of ABS-CBN because that is against the freedom of speech and of the press, particularly of the press. So whenever we say freedom of speech, it carries also the freedom of expression. It carries also the freedom of expression. Okay, guys? So those are the constitutional limitations. What are the use, again, of these constitutional limitations and inherent limitations? They will limit the taxing power of the state. So the legislative, in creating the laws, they are restricted with these limitations, meaning you cannot tax the government. You cannot pass this without the concurrence of the majority of the Congress. You cannot tax the freedom of speech. You cannot tax the freedom of religion. You cannot also tax the revenue of the non-stock, non-profit educational institutions. So you are guided in the exercise of your taxation power as to these items. So they are restrictions over your taxation power, whether inherent or constitutional. We go now to our next topic, that is the aspects of taxation. These are the aspects of taxation. So aspects of taxation. So the aspects of taxation are levy, assessment, and collection. So they are called the aspects of taxation because they are the process of taxation or the system of taxation. And when we say these are the process or the system of taxation, they are shared both by executive and legislative. Okay, so it is shared both by executive and the legislative. Therefore, these processes, levy, assessment, and collection, are done by executive and legislative. So we start first by defining levy. So what is levy? Levy is the imposition or making of tax laws. So it is the making of tax laws. Assessment is the imposition of taxes to the taxpayers. And collection is the enforcement of tax against taxpayer. Okay, so why do we call them the process of taxation or system of taxation? So first we have your tax laws. And then these tax laws will be applied to a taxpayer. It will be applied to a taxpayer. So through the tax law, you will assess the taxpayer, and the taxpayer will pay the taxes through the BIR. So we call this payment or through the BIR and taxpayer as the process of collection. Now, we said that it is shared both by executive and legislative. So we have here levy, assessment, and collection. Levy, assessment, and collection. So levy is also known as your tax legislation, while assessment and collection is known as your tax administration. So why do we say it is shared by executive and legislative? Because tax legislation is the work of the legislative. Tax administration is the work of the executive. Okay, so levy is also known as tax legislation, and assessment and collection is known as your tax administration, the work of your executive and your legislative. Now also, levy and assessment can also be known as your impact of taxation. So why is it known as your impact of taxation? Because without levy and assessment, there is no tax. Without levy and assessment, there is no tax. And how about your collection? It is known as your incidence of taxation. Because of the taxation or because of your levy and assessment, there is now tax. Because of your levy and assessment, there is now tax. So incidence of taxation. So we have here tax legislation, tax administration as to levy, assessment, and collection. We also have impact and incidence of taxation as to your levy, assessment, and collection. So true or false? Assessment is tax legislation and impact of taxation. False. Collection is tax administration and impact of taxation. False. Because collection is tax administration and incidence of taxation. Ganon siya. Okay? So please remember that the process or the system of taxation happens through levy first, and then we assess, and then we collect. So those are the aspects of taxation. We go now to the different concepts of double taxation. I thought we go now to the different doctrines in taxation. We start first with concepts of double taxation. So what is the concept of double taxation? The rule is you can only tax once. You can only tax once, because if you tax twice, it is double taxation. It is unconstitutional. but we will learn that there are two kinds of double taxation: direct double taxation and indirect double taxation. What is unconstitutional is the direct double taxation. This is prohibited under our laws and under the Constitution, while indirect is legal. Indirect is legal. So what is double taxation? It is taxing the same property twice when it should be taxed once. So you tax twice a property or a subject matter once. And what are the requisites of double taxation? What are the requisites of your double taxation? So the following are the requisites of double taxation. First, same property or subject matter. Same property or subject matter. Second, we have your same purpose. Third, same taxing authority. Fourth, we have your same jurisdiction. Fifth, same character of tax. Sixth, same taxing period. Okay. So, kailan ba natin masasabi na direct double taxation siya? Pagka meron tong anim na to. So, same property, same purpose, same taxing authority, same jurisdiction, same character of tax, and same taxing period. Take note of this. Doon lang magkakaroon ng direct double taxation. Sir, what happens if one of the items there is not present? So, let's say it is not same character of tax that is in direct double taxation. It is legal. It is legal. Indirect double taxation, it is legal. If ever, lahat nito ay present, direct double taxation. Ang sabi natin, prohibited yan, bawal yan. So pag ginawa sa inyo yan, oy, direct double taxation yan, hindi mo ko pwedeng i-kolekta uli niyan. Pero pagka isa nitong requisites na to, let's say same character of tax, hindi same yung character ng tax, indirect double taxation, legal yan. Legal yan. So for example, taxing authority, yung isa levied by the national government, yung isa levied by the local government. Okay. So same na tinatax yung property mo, same na property. However, yung isa from the national government, yung isa from local government. Is there double taxation? Only indirect. Therefore, it is legal. Take note, only when the 6 items are present, we can say that the double taxation is prohibited. Okay, we go now to your other doctrines in taxation. Let's just try to finish this one. If we cannot finish it, we continue next meeting. So first, we have your doctrine of equitable recoupment, not applicable in the Philippines. So what is equitable recoupment? Equitable recoupment in taxation applies if ever there is an overpayment of tax. There is an overpayment of tax. So if you overpaid your taxes and suddenly you have a missing tax or underpaid tax, you cannot recoup the underpaid tax with the overpaid tax. So meaning, hindi mo pwedeng ipambayad yung overpaid doon sa underpaid. You cannot recoup it, okay? Because taxation is the lifeblood of the government. However, you will learn soon that there are other methods in which the overpaid tax can be used, such as tax credit. When we say tax credit, ang gagawin lang, magbabawas lang siya. Magbabawas lang. And it can also be through tax refund, and your withholding system. So again, doctrine of equitable recoupment, not applicable in the Philippines in case of overpaid taxes. Next, a tax may not be subject of compensation or set-off. So what is a compensation or set-off? Again, you have learned this item in your obligations and contracts, that you can only use compensation for contracts. These are modes of extinguishment, and compensation or set-off is a mode of extinguishment, a contract. It is a mode of extinguishment of a contract. So what is a compensation again? When the debtor and creditor are debtors and creditors of each other. So for example, sulat natin. Si A umutang kay B. A may utang kay B 10,000. Si B may utang kay A 20,000. Okay? 10,000 and 20,000. A may utang kay B, 10,000. B may utang kay A, 20,000. When we say compensation, set off mo na lang yan. So, kukunin mo yung net, 10,000 na lang, di ba? Pero tax is not subject to compensation because compensation is applicable only to contracts. And I told you, tax is based on law. Tax is based on law. Therefore, you cannot apply the rule of compensation in our tax. And further, tax is the lifeblood of the government. Tax is the lifeblood of the government. We were trained in law school that in case you have a question on a tax and you don't know the answer, your answer should be, tax is the lifeblood of the government. Ganun daw. But anyway, I told you, pag ganyan ang tinanong, why is tax not subject to compensation or set off? Because tax is not arising from contract. Therefore, the rules on the extinguishment of contract does not apply to it. Tax arises from obligations from law. Okay, that's for number 2. Number 3, doctrine of strictissimi juris. So what is this strictissimi juris? The doctrine of strictissimi juris is the doctrine regarding tax exemptions and tax laws. Tax exemptions and tax laws, sorry. Doctrine of strictissimi juris, tax exemptions and tax laws. So under your doctrine of strictissimi juris, it means that in a tax exemption, it is strictly construed against the taxpayer. Why? Because again, when you say tax exemption, it is the taxpayer who applies the tax exemption. So it is strictly construed against him, meaning it is up for the taxpayer to prove that really there is a tax exemption. So before the tax exemption will be applied to the taxpayer must be able to prove that there is a tax exemption. Kaya nga, strictissimi juris, strict law application. So if the law application is tax exemption, it is strictly applied against the taxpayer. The taxpayer must prove it. How about strictissimi juris tax law? Tax laws is strictly construed against the government. Okay? It is strictly construed against the government. It means that if the government will tax something based on a law, the government must prove that there is a tax law that taxes that something. Okay? So any tax law that is used by the government must be proven by the government. Any tax exemption that will be used by the taxpayer must be proven by the taxpayer. That is your doctrine of strictissimi juris. Number 4, tax laws operates prospectively. What do we mean by tax laws operates prospectively? We mean that if ever a tax law is approved or signed by the president, it will apply to the current and future periods. It cannot apply to periods before the signing of the law. So it will only apply in the current and future periods. Current and future periods. Next, taxes are not assignable. Why? Because taxes are the lifeblood of the government. You cannot really assign a tax. You cannot really assign a tax. So for example, I have a tax due to the government. I cannot tell that, oy, government, you collect na lang B. That cannot be. That cannot be. Because taxes are personal in nature. It is your own obligation. It is strictly enforced to you as a person, not to other persons. Therefore, you cannot assign it to other persons. Next, doctrine of estoppel is not applicable in government. What is this doctrine of estoppel? When doctrine of estoppel applies, it means that a taxpayer cannot tell to the government that because of the previous actuations of the government, it is a stop to collect taxes. So let's have an example. So the government, let's say employee A, pumunta si 1 kay employee A. Employee A, magbabayad ako ng tax. Sabi ni employee A, ay hindi ka pwedeng magbayad ng tax, exempted ka naman. Tapos, soon, pumunta si BIR kay 1. 1, kailangan mo magbayad ng tax. Mali pala yung sinabi ko nung una. Pwede bang sabihin ni 1 na, Doctrine of Estopel, you are stopped to collect taxes to me because of your previous actuation, which is you told me that I am not liable to pay tax. Therefore, you are stopped now to collect tax. Pwede ba yan? No. Because Doctrine of Estopel not applies to government. When we say not applies to government, the government employee itself is whatever is the actuation of the government employee, it will not bind the government. It will not bind the government. Okay, so number 6 yon. Number 7, right to collect unpaid taxes does not prescribe. So what does we mean, or what do we mean whenever we say right to collect unpaid taxes does not prescribe? The BIR or the government can always collect unpaid taxes. The BIR can always collect unpaid taxes, except under our laws now in the NIRC, we have now the prescriptive periods. What is the prescriptive periods? What do we mean by prescriptive periods? Whenever you hear the word prescription, it means the lapse of time. Because of the lapse of time, you cannot already enforce the obligation. Because of the lapse of time, you cannot already enforce the obligation. Prescriptive period. So under our NIRC, we now have a prescriptive period. That is 3 years if without fraud, 10 years if with fraud. So for example, you are to assess. So 2020 yung kanyang tax return. Pwede mo lang siyang i-assess until 2023 kasi nga 3 years, di ba? Pero kung without fraud yan, 3 years lang. Pero kung with fraud, 10 years. So pwede mo siyang i-assess until 2030. Okay? So although here, right to collect taxes does not prescribe, we have now your prescriptive periods to assess taxes under the NIRC, 3 years and 10 years. Okay? So the prescriptive period as a rule, that is before. And last doctrine, Marshall and Holmes doctrine. I know you keep on reading these doctrines. First, Marshall doctrine. The power to tax is the power to destroy. Why so? Because again, you can regulate using the power of taxation. Example nga natin kanina. You can tax 100% an entity so that you can destroy that entity just to regulate that entity. That's Marshall doctrine. How about Holmes doctrine? The power to tax is not the power to destroy so long as the court sits. Meaning, as long as there is the power of judicial review, even if there is a tax law, Holmes doctrine is applicable. Okay? So, even if there's tax law that will regulate something, to destroy something, it can be reviewed by the Supreme Court, by the power of judicial review. Okay? So, we end our discussion here.